financial problems, elder law, tax problems, business matters, divorce, personal injury, bankruptcy, your life, your reality. Life is complicated. There is the law and there is reality. Welcome to Law and Reality, sponsored by Thav Gross. Now here's your host, Ken Gross.
Welcome to this segment of Law and Reality. Today's topic is Mom and Dad need an estate plan. Meanwhile, one of the kids has problems. Jenny Lingle, nice to see you.
Good to be here, Ken.
Chair number A.
Yep.
Chair B,
I'm center.
Jeffrey Kirshner.
I'm like center square.
Center stage.
Nice to be here.
And chair number 1, Brian Small.
Wait, all right. So she's chair number A.
She's A, B,
You
you're
said
what?
number A. He's chair B, and I'm chair number 1.
Yes.
But I'm
Did I
center.
say-
And I'm center square.
Welcome
though,
to
so it's-
Confusion is You.
Well, last week I said chair number 1, chair number 2, and I called you A. Because I know you don't like to be third. That's what I was trying, but so I get confused. But all right, let's stay with the topic. We're talking about mom
is
and
that
dad.
an age thing, Ken?
Maybe. Well, and we're talking about mom and dad. Mom is 75. Dad is 78. Okay? They own a home. It's worth $300,000, free and clear. They've got $400,000 in savings. They're on Social Security. They're bringing in $3,000 a month on their Social Security.
What type of savings?
It's
Is it just a mixture, or is it
a
all in
mixture.
IRAs and
It's
401s?
a mixture.
Okay.
And so mom and dad are and they're healthy. So we don't have any serious problems, but they've come in and they need an estate plan, and we want them to consider what options and things they need to look at. But things are going all right. They're living comfortably they followed the 3-point plan. They own their home free and clear, they have zero debt, and they have some savings. So they have enough coming in every month with their $3,000 to basically cover their overhead, and their savings is they're tapping it as they choose for vacations and having fun. They're comfortable.
Do mom and dad have long-term care insurance?
They do not.
Uh-oh. That could be a problem.
So it could be a problem if mom or dad ends up needing nursing home care and long-term care, then they could become a Medicaid issue.
Well, Medicaid will just take their money unless they do Medicaid planning properly.
At $10,000 to $12,000 per month.
That'd be
with an
about-
average stay of 32 months.
There goes
But it's not
320 grand.
But at this point, it's something for them to consider. But they're not in their 80s, they're not 90, and they're both healthy.
And the fact remains, actually, that if they need Medicaid planning and it's a married couple,
We can do it.
we can protect every dollar up to the day, including the day before mom or dad goes into the nursing home.
That's when it's a couple. If you're widowed, then then it's more important to get ahead of the planning, because that 5-year rule can really hurt you. It can hurt you almost to half of your assets. But let's assume mom and dad don't want to do any Medicaid planning right now,
Well, they do at least need a normal estate plan,
which would include a durable power of attorney.
a medical power of attorney, a will, and a trust.
Absolutely. So let's talk about the durable power. What are they going to? Why is that an important document?
Well, let's just say, let's make it an easy reason why you need a durable power of attorney. Mom is homebound. She's recovering from a surgical procedure and she can't get out. So dad needs to go handle all of the financial affairs of the house.
Or vice versa.
Or vice versa, right. So with that power of
Wait,
attorney,
is it vice versa
No, it's
or
vice
vice versa?
it's
Because
vice
you're
versa.
picking on me with 1, 2, 3, and
I
A, B, C.
understand.
Okay, go on.
Anyway, regardless of who is able to get out of the house, they need that document to establish their ability to do things. Let's say there's
So what does the durable power do?
it allows whoever is given the power to make the same financial decisions that the person who granted the power can make. Buy stock, sell stock, buy a house, sell
Argue
a
with
house.
Comcast.
Argue with Comcast.
Order a TV. on somebody's credit card.
Yeah.
Do all the things that
It lets you make financial decisions. Now, quite often when you're in your elder years, you're going to have the power of attorney is going to be each other's spouse, but you might also have it be your children. Because as you really reach advanced age and you're having trouble paying your bills, seeing the checkbook, writing the checks, things like that, people want to have their kids help them out. And the simple solution they've always come up with is, I'll just add my kid to my bank account. That's the wrong thing to do.
Why is that the wrong thing to do?
Because you don't know what your kid's financial situation is like.
So let's say they have to file a bankruptcy.
Right, so now you've got $400,000. You've added them to your bank accounts for the purposes of helping you out, what we call estate planning purposes. And then you find out that your kid's got $100,000 worth of judgments against them. When do you find that out? When the bank takes the $100,000 out of your account because they got a garnishment.
Big problem.
Huge
now,
problem.
if you can prove that that's really mom's money, will you get it back?
You will. However, you're talking about spending thousands of dollars in attorney's fees.
And you
fighting it.
won't if it's taxes, specifically with the Michigan Department of Treasury. They will
Really?
not give it back.
They'll take half of the money or all of
They
it?
will take all of it.
Because it's both parties'
Unless
money?
it's a minor child, they will say you had 100% access to the money and they will not return it.
So these are horrible mistakes that people too often make, and it's kind of like what we call the old school. The old type of estate planning was just put your kid's name on your asset, on your bank accounts, on your property. Don't bother doing the will. Don't bother doing the trust. What about the trust? Why you hear people say do a trust as opposed to just a will?
All right. So when I do an estate plan,
what's the reason?
I will tell you this: there is no difference, effectively, between a will and a trust in the way it gets assets to whoever you want it to go to. If you said in your will, I want my stuff to go to the Dog and Cat Foundation of America, and you say in your trust, I want it to go to the Dog and Cat Foundation of America, it's going to the Dog and Cat Foundation of America, with one exception. A will, you must go through probate. A trust does not require probate, saving you thousands of dollars on a big estate.
And time, too.
And time.
Time, the probate process. Probate is public, whereas a trust is a contractual arrangement and it goes privately.
And it's a guarantee, as opposed to the will that can be subject to interpretation.
And when we get a little bit later into the show, you're going to see there's another reason why it's important for the assets to fund to your children through a trust rather than just going directly, even by a will, from the standpoint of some of the bankruptcy issues we talked about. We're going to take a break. When we come back, we're going to explore the estate plan and also talk about the kids.
Is the debt piling up? Struggling to get by?
It's all about preserving future income. Bankruptcy is one option. When it's right, it's the least costly, most effective way to save your home, eliminate a second mortgage, and wipe out credit card debt. But you need to address the problem now.
We help people with bankruptcy. Call the experts.
Worth Ave Gross. Our firm will solve your problem.
888-235-HELP. That's 888-235-HELP. Carrying too much debt? Resolve your debt. Call Thav Gross.
You don't need to be broke, and you don't need to hit rock bottom. If you have income and you're struggling with debt, dump it. Think about the next 10 or 20 years. If you do what the banks tell you, you'll have nothing to retire with. There is a solution.
Don't waste your future. Call Thav Gross. We're experts at eliminating credit card debt. 888-235-HELP. That's 888-235-HELP.
A lifetime of hard work. If you don't have the right plan in place, you can lose your home, your savings, and more. And you didn't come this far to lose everything. Samasco Law wants you to know that laws are changing. Today, the average cost of nursing home care is $85,000 a year. With proper planning, we can help protect your life savings and get you the Medicaid and nursing home benefits you deserve.
How much can you afford to lose? Call Samasco Law today.
If you're retired and in a financial crisis, there is a way out.
It pains me when I see a retired couple exhaust their savings by paying credit card bills and for a home hopelessly underwater.
Thav Gross specializes in helping retired people in financial crisis.
You just can't keep paying until you're broke. You need to address the problem now.
888-235-HELP. That's 888-235-HELP.
Worth Ave Gross. Our firm will solve your problem.
You can't work. You have to deal with pain and stress. Worse yet, our system for applying for disability benefits seeks to deny you the benefits you're entitled. Jeff Kirschner is an expert in obtaining disability and workers' compensation benefits for his clients. You need to call Jeff before you apply or after you're denied to get the benefits you deserve. 888-235-HELP. 888-235-HELP.
All right, we're back. All right, so Brian, what about the healthcare power of attorney?
Okay, so healthcare power of attorney is another essential document for an estate plan. This is a document that allows someone else to make a medical decision on your behalf when you are not capable of doing it for yourself. If you have
You're comatose in the hospital.
Right, if you have the capacity to make any communication, and that can be interpreted, like if you can blink your answers, your
answers count.
Your answers count, and the person who you've given the medical power of attorney to don't count. But if you're in that comatose situation and you want somebody to take care of you, if you haven't granted a medical power of attorney to someone, what happens is that the hospital will come to you and the doctors will come to you and they'll say, "Oh, you're his wife. What do you think you should do?" And then you'll tell them, and then the hospital will go, that's not really what we think, so we're going to do what's in our best interest as the hospital. They might do what you want as the spouse, but unless you have the power of attorney or you have a court order through the probate court being made guardian over the individual who's sitting comatose, you are not getting your way.
Particularly if you have differing family members, if the family members express different desired outcomes, that puts the hospital in the middle, then the hospital will freeze and not do anything.
The famous case in this is In re Schiavo. Terry Schiavo was in
Florida.
Florida, and her case went to the Supreme Court of the United States because the husband said, pull the plug, the mother said,
Don't.
Nail it into the wall, and nobody could agree, and there was no directive.
That was very sad. It took a long time.
10 years.
And a lot of money. I remember I was actually in Florida when the Supreme Court issued the decision on that because my wife was following the case day to day on that. All right, so different question. Let's talk about the estate plan. Should mom leave all to dad and dad leave all to mom in the estate plan? Here's what the normal estate plan says. I go everything to my wife. If my wife predeceases me, to my kids, and I divide it up, and I say to them, when they're a certain age, they get all the money, and so forth. Is that the right way to do it?
It's a way to do it. You have some concerns.
Here's the big one. Let me give it to you. When mom and dad are maybe 75 and 78, it may not be an issue. But if mom and dad are in their 60s, dad dies, mom is now in control of the entire estate. She's inherited everything from dad, and she has everything that's hers, okay? She then remarries Oliver, the tennis pro, and shortly thereafter, she signs all her assets over and puts them in Oliver's name, unbeknownst to her kids, and she passes away. Oliver now has the entire estate, and the kids get nothing. That stuff happens
every day
in the real world. And if it happens that way, the kids are out. You can fight it, but you will not win in that situation. There's a way to avoid that. And the way to avoid it is husband leaves his assets to wife in trust. All the money can be used for her support and maintenance as she needs it. However, when she passes away, the residuary, the remainder portion of the assets, are designated to go to the children as beneficiaries. And you do that the opposite way for mom's.
If all of it can be used for mom's use, what keeps her from taking the money out?
Because even if she's the trustee, the children as beneficiaries have a right, and if they see that happening, they can object. Or you can appoint one of the kids as a co-trustee to look after it to make sure that it's fairly taken care of. It's not the simplest of issue because it limits the rights in some respect of the surviving spouse, which is a question for the husband and wife together to decide when they're doing their estate plans. But it's something that's important to be thought about, and what we find is people usually don't even think about it.
But aren't there also tax consequences if you pass it into a trust? Can't you avoid some taxes at all?
No tax consequences. No. And first of all, on estate planning, $5.49 million per spouse can pass tax-free on it. So you got 11 million total, and that number's going up with cost of living every year, and it's also one of the items that are on the current tax agenda to be eliminated if that happens. But if the estate tax goes away, it'll probably come back in a few years because that's how the politics work. But the trust avoids probate, which is an avoidance of expense issue. All right, so that's mom and dad. Now let's talk about the kids for a second. Mom and dad have 2 kids. Matt is 60 years old. He's married. He's got no equity in his home. He's injured at work. He can't work. Doctors say he's not going to return to work. He was making $8,000 a month. He's now making $0. He's got $80,000 in credit card debt. He owes taxes from 2011 and 2012 of $40,000. That's Matt. He's in bad shape.
I can put him in good shape.
Bill is actually, Bill is 58 years old, so they had their kids young if you look at their ages. Bill's married, he owns his own home, he's got $10,000 a month in income, he's got no debt, everything's fine for Bill. So let's talk about Matt's issues from the standpoint of what are you guys going to do for Matt, and then I want to finish up and come back to mom and dad, what should they do about their estate plan?
Well, I've got Matt covered. I've got 2 things for Matt. The first thing, obviously, is a workers' compensation claim happened in the course and scope of his employment. We can work on wage loss benefits as well as medical benefits pursuing a workers' compensation claim. If he's going to be unable to work for 12 months or longer, and we can anticipate that, then we're also going to start off with a Social Security claim for him. That's going to take a while.
How long is that going to take?
Well, ballpark 18 months or so between the initial application and when you finally get a hearing or
If
so.
he was making $8,000 a month, how much are you going to get him?
You're talking about $2,500, $2,600 a month.
How much is he going to get on workers' comp?
Workers' comp will be less. Workers' comp, you get 80% of your net income for every week.
And then there's, we've talked about it in other shows where you have to then apportion and carefully structure the settlement on the workers' comp to preserve as much of the Social Security claim.
Right, there's a coordination between the 2.
We come back from a break. We'll finish up on Matt, and then we'll figure out mom and dad.
Tax problems are major problems. Don't let the IRS levy your wages and seize your assets. There is a solution.
Worth Ave Gross, our firm will solve your problem.
If you're behind on your taxes and owe money to the IRS, call Thav Gross.
We've been solving tax problems for 32 years. We stop wage levies, resolve unfiled returns, and obtain the best possible settlements.
Call Thav Gross today, 888-235-HELP.
A lifetime of hard work. If you're approaching retirement and don't have the right plan in place, you can lose your home, your investments, and your savings. And you didn't come this far to lose everything. Putting a solid strategy in place with Samasco Law legally protects your assets as well as your wishes. Since a will doesn't cover you medically or financially, Samasco Law goes beyond ordinary asset management protection to safeguard everything you have.
How much can you afford to lose? Call Samasco Law today.
If you're retired and in a financial crisis, there is a way out.
It pains me when I see a retired couple exhaust their savings by paying credit card bills and for a home hopelessly underwater.
Thav Gross specializes in helping retired people in financial crisis.
You just can't keep paying until you're broke. You need to address the problem now.
888-235-HELP. That's 888-235-HELP.
Worth Ave Gross, our firm will solve your problem.
Time for announcements. Want to remind our viewers to listen to us Tuesdays 11:30 a.m. and Saturdays 7 o'clock a.m. for Law and Reality Live on Praise 102.7 FM. Then on Thursdays from 3 to 4 for Law and Reality Now with Cliff Russell on 9:10 a.m. Also, be sure and go to the website, lawandreality.com, and sign up for our monthly contest. Free $50 Visa gift card, Law and Reality hat, and copy of my book, Dump Your Debt. We have a seminar coming up on Wednesday, December 6, 2017, 6 to 7:30 p.m. 2018 is your year to be debt-free. We're going to go through all the systems and methods that we use to preserve future income for savings. The quickest way to get rid of debt is the fastest, most efficient way. That's the smart way to do it. The quicker you get rid of the debt, the faster you are able to start accumulating savings for retirement. Jeff Kirshner is going to do a special segment on the elements of addressing a disability claim. Attendees get a free copy of my book, Dump Your Debt. Sign up the same way, thavgross.com, lawandreality.com, or call 888-235-HELP. Want to remind our viewers that you can always come in for a free consultation at Thav Gross. If you want to meet with Jeff Kirshner over disability, workers' comp issues, Brian over financial crisis issues, Jenny over tax issues, me over business issues, just go to the website, click on free consultation, or call 888-235-HELP. Also, take a look at the websites, lawandreality.com and thavgross.com. There's some free great reports there. Business formation, loans and grants for small businesses in Michigan, Pat Simasko's Retiree's Guide to Social Security, and my report on how to save your home with Regulation X, The Hidden Secrets. We'll be right back.
Is the debt piling up? Struggling to get by?
It's all about preserving future income. Bankruptcy is one option. When it's right, it's the least costly, most effective way to save your home, eliminate a second mortgage, and wipe out credit card debt. But you need to address the problem now.
We help people with bankruptcy. Call the experts.
We're Thav Gross. Our firm will solve your problem.
888-235-HELP. That's 888-235-HELP. If you're retired and in a financial crisis, there is a way out.
It pains me when I see a retired couple exhaust their savings by paying credit card bills and for a home hopelessly underwater.
Thav Gross specializes in helping retired people in financial crisis.
You just can't keep paying until you're broke. You need to address the problem now.
888-235-HELP. That's 888-235-HELP.
We're Thav Gross. Our firm will solve your problem.
You can't work. You have to deal with pain and stress. Worse yet, our system for applying for disability benefits seeks to deny you the benefits you're entitled. Jeff Kirshner is an expert in obtaining disability and workers' compensation benefits for his clients. You need to call Jeff before you apply or after you're denied to get the benefits you deserve. 888-235-HELP. 888-235-HELP. Carrying too much debt? Resolve your debt. Call Thav Gross.
You don't need to be broke, and you don't need to hit rock bottom. If you have income and you're struggling with debt, dump it. Think about the next 10 or 20 years. If you do what the banks tell you, you'll have nothing to retire with. There is a solution.
Don't waste your future. Call Thav Gross. We're experts at eliminating credit card debt. 888-235-HELP. That's 888-235-HELP. Tax problems are major problems. Don't let the IRS levy your wages and seize your assets. There is a solution.
We're Thav Gross. Our firm will solve your problem.
If you're behind on your taxes and owe money to the IRS, call Thav Gross.
We've been solving tax problems for 32 years. We stop wage levies, resolve unfiled returns, and obtain the best possible settlements.
Call Thav Gross today, 888-235-HELP.
All right, so Jeff, so in Matt's situation, he's got a workers' comp claim, he's got a Social Security disability claim, but it's going to take him 16, 18 months before he starts seeing money on Social Security disability. Brian, Jenny, what about his $80,000 in credit card debt? What about his $40,000 in taxes?
So typically when I would see a client like this, and I would be bringing Brian in because the taxes are old enough to be dischargeable in bankruptcy. I believe it said they were 2011 and 2012. So the tax had to have come due 3 years ago. So 2012 was due in 2013. So 2016, which were passed, as long as he filed it more than 2 years ago and there's been no additional assessments in 240 days, I would be likely calling Brian in to say, even though I could probably fit him into an offer, I think a bankruptcy would better handle the
Because then you don't have that 5-year look back
You don't have it, plus I can't handle the credit cards in the offer.
So, is this a good Chapter 7?
It's an excellent Chapter 7 for more than one reason. One, Matt's got a lump sum of money coming from Social Security disability when Jeff gets him
in
his
a year
award.
and a half or so.
Two, workers' compensation, as you receive it, is exempt from attachment by the creditors
So
and by the trustee in a bankruptcy. So he gets to keep his income, and his real problem is he's got no equity, he's got debt. So we can wipe out his debt, get him a fresh start, eliminate the taxes, eliminate the credit cards, and when he comes out on the other side of his Social Security disability claim, he gets to keep the lump sum.
So long as you file your bankruptcy before he gets that lump sum.
Correct.
Of
Before
money.
he gets the Social
Before he
Security
gets the
lump
Social
sum.
lump sum.
The
correct.
Social Security, the right to receive it is a protected asset. If you have received it, it's not.
Then it's because that's going to be a big chunk of money at that point.
Right, but
because
once
of
it touches the
material.
bank account, all bets are off. So you've got to take care of it with Brian.
All right, let
before
me
you get
change up the facts now. Okay, mom and dad, same situation with Matt and Bill with the kids, but mom and dad, even though they were healthy, dad passed away. 3 months later, mom passes away. Mom has a will. She didn't do a trust. And the will left 50% to Matt and 50% to Bill.
Well, Bill's got no
Bill's
issues.
fine.
Matt's
What if
got a
Matt
problem.
filed that bankruptcy and mom dies within 180 days of his filing the bankruptcy?
So because the assets are going through a will and not a trust, Matt inherits the assets by way of bequest, devise, or inheritance,
That's
or
code-
through
the-
intestate
the
succession.
mean code section 541A5A. Okay, so that means what?
That means that that property that Matt is inheriting,
Which is probably close to $400,000. The house and
Yeah.
half of the cash.
it becomes property of the bankruptcy estate, and the Chapter 7 trustee will take assets sufficient to pay off Matt's creditors.
so he won't lose all the money, but he'll have to pay all the credit card debt.
120 grand, and that's something that could have been stopped by doing a trust instead.
Wait a second. By doing a trust?
Yes, by doing a trust.
How would that have
Because
stopped it?
a trust is not considered a will, a devise, bequest, or inheritance.
So if mom had a trust and mom's assets were funded into the trust while she was living,
Then
and
Matt
then
would get
she
to
passes
keep
away.
all of it.
that's something very few people know about.
What's really, and then to be doubly protected, we could have just had mom create a spendthrift trust where Bill was the trustee of Matt's trust, and no creditors could have gotten to it anyway.
And that would be something that you would do in a situation where even if Matt wasn't filing bankruptcy,
Or he
if
was
you just-
ineligible to file bankruptcy.
You wanted to protect the money so he would have it available for his support, but you wouldn't want to be able to reach it with the creditors. You need a spendthrift provision in the trust.
with discretionary powers to the trustee.
When we say discretionary, we mean if Matt could have the right to take all the money at his own choosing, then it's not discretionary, and then in that circumstance, the spendthrift provision wouldn't work. But if the trust says Bill is the trustee over Matt, he decides how much Matt gets for his reasonable support, and there's a spendthrift provision, then Matt's protected. And not only is Matt protected, remember, mom and dad are protected because they didn't work their whole lives to want to then pass away and leave their assets to go to the creditors of their children, or to the government for that matter. That's a wrap. Have a great week. We'll be back next week with Law and Reality.